Okay, Tammy, we're live.
Great. Good afternoon. LAFCO will now call the San Diego County Local Agency Formation Commission protest proceedings hearing for the conditional approval of the Fallbrook Public Utility District Reorganization Wholesale Water Services LAFCO file number RO 20-04 to order at 1 o'clock.
Thank you, Tammy. On behalf of the Executive Officer, Keen Simons, my name is Priscilla Mumpower, Assistant Executive Officer for San Diego County LAFCO. I served as Project Manager for the Fallbrook Public Utility District Reorganization Proposal for the transfer of wholesale water services from the San Diego County Water Authority to Eastern Municipal Water District. Today, I'm serving as the Delegated Hearing Officer. Pursuant to Government Code Section 57050, we're here today to conduct protest proceedings for the conditional approval of the Fallbrook Public Utility District Reorganization Wholesale Water Services. Notice of the protest hearing was published in the San Diego Union Tribune on Thursday, July 27th in English and in Spanish. It was noticed that the protest hearing period will commence on Friday, July 28th and end at the close of today's hearing. It was also noted that it serves as an opportunity for landowners and/or registered voters within the affected territory to submit or withdraw formal protest against the Commission's July conditional approval of an application by Fallbrook to annex into the Eastern Municipal Water District and thereby transfer wholesale water service responsibilities away from the San Diego County Water Authority. Moving on to item 2C and the availability of protest forms, forms to withdraw protest, and speaker slips. We have 3 different speaker slips available to the audience, one in opposition, one in support, and one as a request to provide public comment. We also have protest forms, a landowner protest, registered voter protest, and a protest to withdraw a previous protest submitted. So if you've come today to provide public comment, you'll have your opportunity during the public comment period and to speak for a total of 3 minutes. When the time comes, I will officially invite you to file a written protest or withdraw at the very end of this process. And then we will provide a preliminary count of the protests already received, as well as those received today. So with this said, I do know that we have 1 public comment that we've received. Do we have any public comments in the room?
No.
Okay, with that said, I'm going to go ahead and turn it over to analyst Michaela Peters, who will read into the record a comment letter received by the San Diego County Water Authority.
So this is from David J. Edwards, General Counsel for SDPWA. And it reads, Dear Mr. Simons, the San Diego County Water Authority submits these comments for the protest hearing on LAFCO's illegal and improper conditional approval of the Rainbow Municipal Water District reorganization. As the Water Authority has submitted to San Diego LAFCO many times during these proceedings, there are multiple fatal flaws with LAFCO's conditional approval of Rainbow's detachment from the Water Authority and annexation into the Eastern Municipal Water District. Among these flaws is the fact that LAFCO failed to comply with the California Environmental Quality Act in conditionally approving Rainbow's detachment and annexation by finding that the annexation would be exempt from CEQA review. Neither the so-called common sense exemption, CEQA guidelines section 15.061B3, nor the class 20 categorical exemption, CEQA guidelines section 15.320, apply to exempt Rainbow's detachment and annexation. LAFCO must rectify these errors before completing approval to the reorganization. With regards to the common sense exemption, it cannot be seen with certainty that there is no possibility that the reorganization may have a significant effect on the environment. In fact, the opposite is true. Rainbow's detachment and annexation will change both the water supply source and who delivers the water to the district. Furthermore, as the Water Authority has previously advised LAFCO, the change in water supply will necessitate the construction of new water infrastructure and change in water treatment. Chief among these required improvements are those planned to accommodate Rainbow's change in water supply owned and delivered from the Water Authority to delivery of Metropolitan Water District owned water by the Eastern Municipal Water District. This is due to the fact that Rainbow would only be receiving water at the northern end of their service area with the reorganization. For example, Rainbow would, if the detachment and annexation are completed, need to either have a portion of their new water supply treated at the Robert A. Weiss plant in the city of Oceanside, which would then be delivered back to Rainbow for distribution to its customers, as is currently being contemplated by Rainbow, or construct a brand new treated water conveyance pipeline from the northern part of their service area to connect to the southern part for the ability to serve treated water. As part of their plan to treat water at City of Oceanside's waste plant, Rainbow would need to construct a new pump station and new conveyance pipeline to service the southern portion of Rainbow's service area. Clearly, construction of the new pump station and pipeline, as well as the energy costs for newly pumping water to the city of Oceanside and to Rainbow's distribution system, has the possibility of significant effects on the environment, including but not necessarily limited to air quality, biological resources, cultural and tribal cultural resources, energy, geology, and soils, greenhouse gas emissions, hazards and hazardous materials, hydrology and water quality, noise, transportation, and wildfire, as well as cumulative impacts. Indeed, Rainbow itself recognized these potential impacts by studying the proposed project in the Rainbow Municipal Water District Water and Sewer Facilities Plan Draft Program Environmental Impact Report, which was published last year. Rainbow published and certified the final EIR in August 2022. As such, LAFCO is required to examine the full impacts of the proposed reorganization before completing approval of the reorganizations. Moreover, the Class 20 exemption does not apply on its face. Class 20 applies only where the changes in organization do not change the geographic area in which previously existing powers are exercised. Examples of this type of reorganization include: 1, establishment of a subsidiary district; 2, consolidation of 2 or more districts having identical powers; and 3, merger with a city of a district lying entirely within the boundaries of the city. Here, the proposed detachment reorganization would remove Rainbow from the Water Authority and annex Rainbow into an entirely different entity in an entirely different county. Plainly, this type of reorganization is one that changes the geographic area in which previously existing powers are exercised, and thus the Class 20 exemption does not apply. Even if the Class 20 exemption were to apply on its face, the categorical exemptions are subject to the exceptions in CEQA guidelines section 15300.2. Section 15300.2C provides that a categorical exemption shall not be used for an activity where there is a reasonable possibility that the activity will have significant effect on the environment due to unusual circumstances. As set forth above, the reorganizations contemplated by CEQA guidelines section 15320 are of the type that result in no real change in the physical boundaries or powers of the entities involved in the reorganization, nor in the infrastructure necessary to service the newly created entity. Here, the switch from the Water Authority to Eastern Municipal Water District will involve an unusual change in boundaries and result in the extensive environmental impacts resulting from the change in water supply, as well as the income related to structure to use that new water supply from a new provider as described above. For all of these reasons, San Diego LAFCO should use the opportunity of this protest proceedings to rescind its previous approvals and conduct appropriate CEQA review before taking any further action on the proposed attachment and annexation.
Thank you, Michaela. So seeing no other public comments or requests, I'm going to go ahead and move on to agenda item number 4, the protest hearing, and beginning with the recitals of approval. So LAFCO staff will read into the record the resolution of approval by the commission on July 10th, 2023, conditionally approving with a 5-3 vote the Fallbrook Public Utility District Reorganization Wholesale Water Services proposal. And beginning with the first. So whereas on March 18, 2020 and March 19, 2020, the Rainbow Municipal Water District and Fallbrook Public Utility District respectively filed a resolution of application to initiate proceedings with the San Diego County Local Agency Formation Commission, hereinafter referred to as Commission, and pursuant to the Cortez C. Knox Hertzberg Local Government Reorganization Act of 2000. And on April 28, 2020, the executive officer administratively combined the proposals for hearing purposes. Each application seeks approval to reorganize and transfer wholesale water service responsibilities within each applicant's jurisdictional boundaries, totaling approximately 79,000 acres from the San Diego County Water Authority to Eastern Municipal Water District. Of that total acreage, the jurisdictional boundaries of Fallbrook total approximately 28,193 acres. The combined proposals necessitate concurrent annexations to Eastern Municipal Water District and attachments from San Diego County Water Authority with conforming sphere of influence amendments to accommodate the jurisdictional changes. On October 24th, 2019, pursuant to Government Code Section 56-124, San Diego LAFCO entered into a memorandum of understanding with Riverside LAFCO. The MOU delegates to San Diego LAFCO the responsibility to process the combined proposals and prepare related analysis, including but not limited to a municipal service review on Eastern MWD to inform a conforming sphere of influence action. On April 2nd, 2020, pursuant to Government Code Section 56-127, County Water Authority applied for non-district status for purposes of Part 4 of CKH as it relates to the combined proposals. On May 4th, 2020, pursuant to Government Code Section 56-128, San Diego LAFCO determined County Water Authority is not a district or special district for purposes of Part 4 in conducting authority proceedings of CKH as it relates to the combined proposals, resulting in protest and election proceedings taking place under County Water Authority's Principal Act, should the Commission approve Fallbrook Public Utility District or Rainbow Municipal Water District's reorganization proposals. On June 1st, 2020, San Diego LAFCO approved the establishment of an advisory committee to directly assist the executive officer in the administrative review of the combined proposals. And on February 7th and March 7th, 2022, San Diego LAFCO received and approved the final report on scheduled municipal service review on the Fallbrook region and the local agencies operating therein, subject to the Commission's oversight, including Fallbrook Public Utility District and Rainbow Municipal Water District. And an applicable master property tax transfer agreement dated December 2nd, 1982 applies to the combined proposals. The Commission's executive officer has reviewed the proposed reorganization and prepared a report with recommendations. The executive officer's report and recommendations on the proposal have been presented to the Commission in the manner provided by law. Staff published an advertisement notice of public hearing regarding this proposal in the San Diego Union Tribune and Village News on April 24th and May 4th, 2023, respectively. The Commission then heard and fully considered all the evidence presented at a notice public meeting on the proposal on June 5th, 2023 and July 10th, 2023. And the Commission considered all the factors required by law under Government Code Sections 56-425 subdivision A and 56-668 and adopted local policies and procedures. Now, therefore, the Commission does hereby resolve, determine, and order as follows. The recitals above incorporated herein by reference. At the hearing, the Commission called for, heard, and considered all public comments by interested parties and read and considered the executive officer's report. The Commission serves as responsible and lead agency under the California Environmental Quality Act in considering the two distinct projects associated with the proposed reorganization and as detailed in the executive officer's report for both A, the reorganization, and B, the related conforming sphere of influence action. The Commission's findings follow. Fallbrook Public Utility District and Rainbow Municipal Water Districts initiating actions involving the reorganization proposals position the agencies to serve as lead agencies in assessing the potential impacts, and specifically the annexation to Eastern MWD and detachment from County Water Authority under CEQA. In their roles as lead agencies, both Fallbrook and Rainbow have made findings that the proposal qualifies as a project, but is exempt from further review under state CEQA guidelines 15-320. Staff independently concurs this exemption appropriately applies given the underlying action involves the transfer of existing municipal service functions within the same area with no additional powers or expansions therein. San Diego County LAFCO serves as lead agency under CEQA for the conforming sphere of influence actions associated with accommodating the reorganizations. It is recommended the Commission find these actions and specifically establishing a sphere for Eastern, covering its wholesale function to include the affected territory and concurrently removing these lands from the County Water Authority sphere collectively qualifies a project under CEQA, but are exempt from further review under state guidelines 15061. Subsection B and 3. This exemption appropriately applies given it can be seen with certainty that spheres or planning policies and any associated actions in and of itself does not change the environment or authorize any new uses or services. The commission approves an amendment to Eastern's sphere of influence to include the affected territory and concurrently remove these lands from the County Water Authority sphere, as shown in the agenda report. The commission approves the reorganization without modifications and subject to conditions as provided. The commission conditions all approvals the following terms being satisfied by July 10th, 2024, unless an extension is requested in writing and approved by the executive officer. Completion of the 30-day reconsideration period provided under Government Code Section 56895. Submittal to the commission the final map and geographic description of the affected territory as approved by the commission, conforming to the requirements of the State Board of Equalization Tax Services Division. Submittal to the commission of the following payments. A check made payable to LAFCO in the amount of $100 for the San Diego County Clerk Recorder's Office to reimburse for CEQA filings. A check made payable to the State Board of Equalization for processing fees in the amount of $3,500. A check made payable to San Diego LAFCO in the amount of $1,439.96 to reimburse 1/2 of the cost of public hearing notices published in the San Diego Union Tribune. A check made payable to San Diego LAFCO in the amount of $400 to reimburse 1/2 the cost of public hearing notices published in the Village News. Within 30 days of the adoption of this resolution, the execution of an obligation to indemnify and hold harmless to the fullest extent permitted by law, the commission, including its officers, agents, employees, and volunteers, from and against any and all claims, losses, costs, and expenses for any damage or injury arising out of or in connection with the combined proposals. And upon the commission's request, the deposit of funds for the defense of the commission. Such costs and expenses shall include reasonable attorney's fees due to counsel and commission's choice, expert fees, and all other expenses of litigation. Pursuant to Government Code Section 56888-886, subdivision B, the commission imposes an exit fee of $8,506,750 to be paid to the County Water Authority in 5 annual installments of $1,701,350. The first payment shall be made to the County Water Authority within 30 days of the certification of the election results described below, if a majority of the electorate votes in support of Fallbrook's proposal. The four remaining annual installments of $1,701,350 for the exit fee described in 6E above shall be paid to the County Water Authority on successive yearly anniversaries of the initial payment until completed. The commission assigns a proposal the following short-term designation: Fallbrook PUD Reorganization. The affected territory as designated by the commission is inhabited as defined in Government Code Section 56046. The commission delegates to the executive officer the performance of all conducting authority proceedings requirements under Government Code Section 5700 for purpose of the Eastern Municipal Water District annexation. Pursuant to Water Code Appendix Section 4511, Subdivision A2, Board of Directors of Fallbrook PUD shall submit to its electors at the next available general or special election the proposition of detaching from County Water Authority. The provisions of the County Water Authority Act regarding such elections in effect at the time the executive officer issued the certificate of filing for the proposal shall govern such election. In the above referenced election, the voters shall approve the proposition of detaching from County Water Authority. Eastern Municipal Water District is a registered voter district. Eastern Municipal Water District utilizes the County of Riverside assessment rule. The affected territory will be liable for any existing bonds, contracts, and or obligations of the Eastern Municipal Water District as provided under Government Code Section 57328, and will be subject to any previously authorized taxes, benefit assessments, fees, or charges of Eastern MWD provided under Government Code Section 57330. which Eastern MWD shall be authorized to assess, levy, and or collect within its boundaries. Pursuant to Government Code Section 57-202, the effective date of the approval shall be the date of recordation of the certificate of completion, but only after all terms set forth in number 6 above have been completed as attested by the executive officer. As allowed under Government Code Section 56-107, the commission authorized the executive officer to make non-substantive corrections to this resolution to address any technical defects, errors, irregularities, or omissions. Under Government Code Sections 56-880 through 56-882, the executive officer is hereby authorized and directed to mail copies of this resolution. The executive officer is further authorized and directed to prepare, execute, and record a certificate of completion, make the required filings with the accounting assessor and auditor, and the State Board of Equalization as required by Section 57-200 of the Government Code. This resolution was passed and adopted by the Commission on July 10th, 2023 by the following vote. Desmond, Willis, Drake, White, and Vanderlyn, yes. Whitburn, Anderson, and Becker, no. Mackenzie, absent, none abstain, as attested by our executive officer, Keith Simons. This concludes the resolution and action by the commission. I'm now going to turn it over to LAFCO Commission Clerk Tammy Luckett to provide a summary of protests previously received as we move to 4B on the agenda.
LAFCO received no previous landowner or registered voters protest forms.
Thank you, Tammy. We'll now move on to agenda item 4C, which is the invitation to landowners and our voters that have not already done so to submit written protest or withdraw their previously filed protest. Just to read it to the record, while we don't have anyone that has submitted protest, and I don't see anyone in the room as of yet to provide protest, I'm going to read this into the record. Both landowners and or registered voters residing within the Fallbrook Public Utility District service area may file a written protest through the end of today's hearing. Protests will be first reviewed by staff to determine that protests contain required information, including date, signature, and address. And then they will be validated by sending to the assessor's office and registrar of voters. Registered voter protests will be submitted to the County of Registrar of Voters to verify that the protester is registered to vote within the affected territory, verify the signature, and to correlate the address with the signer. Landowner protests will be submitted to the assessor's office and will verify that the land is located within the affected territory and to value the protest in relation to the total assessed value within the affected territory. State law provides the following thresholds in measuring protests. If less than 25% of landowners or voters protest the commission's early approval at the close of today's hearing, then the action proceeds forward, assuming all other conditions are satisfied. If 25% to 50% of landowner or voter protest the commission's earlier approval at the close of today's hearing, then an election is called and voters decide if the action proceeds. If more than 50% of landowners or voters protest the commission's earlier approval at the close of today's hearing, then the action is terminated and goes no further. And seeing none, we will announce that there are no protests received as to date. And with that, I'm now going to close today's hearing. Thank you very much for attending. The hearing is now adjourned.